Greetings, everyone, and welcome to the Golden 30, a 30-minute program with topics geared towards older adults. My name is Carrion Gray, and I am the Adult and Senior Services Specialist for Prince George's County Memorial Library System. Today, we will be discussing guardianship with attorney Timothy P. Leahy of Byrd and Byrd. But first, let me give a disclaimer. This presentation is for general information only and is not intended to establish an attorney-client relationship and or give legal advice. Tim Leahy does appear courtesy of Byrd and Byrd, LLC Attorneys at Law, and where they believe they're not just good lawyers, they're good counsel. If you would like to call and schedule an appointment with one of these experienced and knowledgeable attorneys, you can reach them at their local location of 14300 Gallant Fox Lane, Suite 120, Bowie, Maryland, or you can call and text them at 301-464-7448, or they can be reached at byrdandbyrd.com. Now, let me tell you a little bit about our guest, Tim Leahy. He is a partner at Byrd and Byrd and practices law in Maryland and the District of Columbia. He is a member of the American, Maryland, DC, and Prince George's County Bar Association. Tim received his Bachelor of Science from University of Maryland and his MBA from University of Maryland Robert H. Smith School of Business and his Juris Doctorate cum laude from the University of Baltimore School of Law. Tim brings over 10 years of business experience to his practice, an Army reservist and former home improvement contractor. He volunteers with the Prince George's County Bar Association's Christmas in April project. Tim has been with Byrd and Byrd for almost 20 years. He focuses his general practice in the areas of civil litigation, family law, criminal law, and construction law. So he's very knowledgeable. Welcome, Tim Leahy. How are you?
I'm doing well. Thank you very much, Karen. I appreciate the opportunity to be here.
Okay, awesome. So we'll just have a little discussion about guardianship. So can you give us like a definition of what is guardianship?
Well, a guardianship is when one person has to act legally for another one or make decisions for somebody else, usually because something has happened to them and they don't have kind of the mental capacity anymore to kind of make good decisions for themselves. And so it's just a way of helping people who can no longer help themselves.
Thank you. So why would I need to obtain guardianship? What would the parameters for that look like?
Well, I think for younger children who are disabled, um, it's very important. I think a lot of times parents don't think about getting a guardianship for their minor child, especially if they've got some sort of special needs, because until a child is 18, you have mostly doctors and other people uh, paying attention to what the parents say. But the moment that the child turns, 18, they are an adult. And, the other type of guardianship that you see is, for people on the other age spectrum, a lot of time with the seniors, unfortunately, Alzheimer's, vascular dementia, these are some of the biggest, killers in the United States. But because it's a slow process, the adults go from being able to be competent, like when a minor turns 18, to really not remembering, well, having memory issues, not remembering to pay bills, leaving the stove on, being more susceptible to scams and that sort of thing. I think, when we, talk to people about who needs a guardianship, we always start with the disabled, the younger children, because if you do a guardianship while someone's a minor, it's very easy to get guardianship because the parents are the natural guardians. And that way, when somebody turns 18, you don't have the parents no longer being able to help, their disabled children, just because someone's now an adult. And then you have to go through the whole guardianship process, which is longer and harder when you're dealing with adults who, for instance, begin to have dementia or have other issues. So I think, anybody with a disabled child should probably consider guardianship. So it survives after they're age 18. And then anybody who, finds themselves with a parent or a loved one who has been diagnosed with dementia, whether it's Alzheimer's or vascular, really need to start thinking about getting a guardianship and just planning so that when someone is not able to make decisions and there's somebody there who will be able to make those decisions. And the guardians are typically kind of monitored by the courts. And so people who might be a little concerned about kind of giving up authority or going through the guardianship process may feel a little bit better knowing that, there's a trust office and a judge that will be watching out to make sure that whoever might be appointed, is doing a good job.
So in terms of guardianship, you spoke about children. So after a child, like let's say if you have a disabled child, so after the child turns 18, would a parent have to seek guardianship for them? Because I believe you said that it is, naturally, the parents, but like after 18, is there a change or what goes along with that?
Right. It's automatic. When someone turns 18 or different states may have a different age of majority, but in Maryland, you're talking about when you turn 18, you're considered an adult. You can legally contract for yourself. So it is, somewhat like, flicking a switch. You go from being a child to being an adult. And, unfortunately, if you are specially abled, uh, you're going to suddenly be treated like an adult. And that means that doctors are not supposed to, are not supposed to listen to just your parents. They're supposed to listen to you. So if you do the guardianship before you turn 18, then you're not going to have to worry about proving through doctors or neurologists that someone is no longer mentally capable of making decisions. If you do it while you're a child, your disability is really being a minor. And the court at that point can look at it and say, we're going to grant a guardianship based on your being a child and understanding that you do have these special or you're specially abled. We're not going to terminate the guardianship just because you turn 18. We're going to keep it in place. And that way there's no interruption of services for children who are going to need that and going to need their parents to help them even after they turn 18.
So what does the process look like? What does the process look like to obtain guardianship? And I guess, does it vary from state to state?
It does. I'm licensed in Maryland and DC, and they act, very similarly. One of the reasons why we do, talk about, people with children who are disabled doing it sooner is because you don't have to get doctors or neurologists to certify that somebody is incompetent. Because when you're dealing with somebody who's, a senior or an adult who's become disabled, you're supposed to have 2 certificates of incompetency, normally filled out by at least one medical doctor. And the other certificate could be somebody, maybe a psychiatrist or a social worker, even an internist. But you've got to get, in other words, 2 very professional people with medical and or social work skills to say that, yes, this person is no longer competent to be making decisions. Then, once you get those certificates, they have to be filed with a petition within 21 days of when the doctor last examined you. And they do the 21 days because people do get better. For instance, if you suffered a traumatic injury, maybe you were in a car accident and you hit your head, you may not be competent for a period of time while you're medically recovering. So the courts insist on the doctor's certificates being within 21 days. And believe it or not, that can be very tough. Doctors tend to be busy, especially with COVID. It's even harder to get somebody in for an appointment. But doing like an adult guardianship is much harder and it's much more complicated. But assuming that you can get the 2 certificates of incompetency, and get them within 21 days of filing the petition, then the court has to appoint an attorney to represent the alleged disabled person. They say ADP is the acronym, because you're only alleged to be disabled until you are proven not to be competent. And it's an actual attorney of the bar whose job is to do what the disabled person wants, to treat the representation just like anybody else with an attorney would have, zealously represent them in some cases. And when you have somebody who, especially later in life, begins to have dementia, whether Alzheimer's type or vascular, it's unfortunately sometimes the fact that they can become defensive, not necessarily understanding that their loss of capacity is related to a disease. And they'll develop a number of defense mechanisms, because you'll hear them say, I don't need a guardian, I don't need any help. And so you might end up with an adult where you're in the guardianship process who has an attorney hired by the court to help them. And that person may be trying to prevent a guardianship from happening, because that may be what your alleged disabled person wants. And then you can have a hearing in court. The way, at least, for instance, Maryland works is the courts will typically schedule a hearing called a show cause hearing, which, if everybody agrees that the guardianship is needed, it's a fairly quick process. They'll go forward on the petition. They'll accept the certificates of the doctors. And I think the court feels like they can do that because the alleged disabled person has an attorney appointed for them to, follow up with the doctors on the certificates and make sure everything is right, and kind of put some neutral eyes and ears on it. And then, help the person who is, unfortunately disabled at this point. However, if you do have somebody who doesn't think that they are incompetent or wants to fight a guardianship, then the court will schedule a contested hearing, and then everybody is in litigation, a lawsuit with a period of, I think, up to 180 days, 6 months, to do discovery, take depositions, propound discovery requests, get documents, that sort of thing. And so you really want to consider trying to avoid guardianship if at all possible, or doing it earlier in somebody's disability, whether they're a minor or just maybe recently diagnosed, to make sure that everybody understands what's going on and why. Maybe you don't have the defensiveness, and you can, hopefully get a guardianship in a slightly less painful process.
Okay. There's a lot of information, but that's good to know, to try to do it as ahead of time as you can. Now, is there more than one type of guardianship? Are there different levels or different types?
Sure. I think most courts, I know, for instance, Maryland and DC have two types of guardians. There's guardians of the person, and there's guardians of the property. And you may hear the term conservatorship. I think, for instance, the District of Columbia, it calls a guardianship of the property a conservatorship. But in essence, the guardian of the property, or a conservator, is in charge of all of someone's property, all of their money, all of their income. And that's to make sure that it's spent the right way, bills are paid, services are provided for. And again, when someone is incompetent, they may be more likely to be taken advantage of. Someone might get access to their accounts. And at least with the guardianship of the property, that money is actually taken out of the name of the person, the ward, the disabled, and put into a guardianship account that is monitored by both the courts, because a report has to be filed, and the bank, because the account is specifically marked as a guardianship account. So even though it's in the name of the guardian, the ward is mentioned, and the bank knows that the funds are being held kind of for their benefit. The other guardianship type is the guardianship of the person. And that is the person who makes a lot of the legal decisions, the healthcare decisions. Oftentimes doctors may not want to make a medical decision when there are several options and maybe none of them are great, or maybe some of them are very risky. And they prefer a family member to do that. But the guardian of the person makes the decisions legally for somebody. And then the difference between that and the guardian of the property, so the guardian of the property will pay for those decisions. There's kind of a sharing of power there, because if the guardian of the person makes a decision, the guardian of the property won't pay for it. It's kind of hard to implement the decision, but in practice, usually the court will appoint one person as both the guardian of the person and property. There is a pretty good distinction, though. Whenever there's any kind of family strife or fighting, allegations that anybody has sort of done something wrong, a lot of times what the court will do is they'll make a family member guardian of the person, because usually everybody has, their loved one's interests at best heart. But instead of making a family member guardian of the property, they'll appoint like an attorney of the bar to handle things. And so that takes it sort of out of the family. And the family will simply have to work with an attorney. And so that goes back to, my point about doing it earlier in the process. Just because someone has an Alzheimer's or dementia diagnosis, if it's early onset, you're at the beginning, you may only be 90% of what you were normally, but you still, know pretty much everything you want to do. And a lot of times, if you're involved in the guardianship process earlier, then that heads off family strife. And you may very well be able to make sure that family is taking care of not only your legal decisions, but your property also, because it can be kind of expensive to have an attorney managing your property.
That's good to know. I heard you mention conservatorship, and that's been very buzzwordy. I don't know if you know, but if the whole Britney Spears and talking about, can really handle your funds and what is a conservatorship. So that's very interesting to hear about that in terms of guardianship. So yeah.
We're going to put this interview out with the hashtag Free Britney.
Yeah. Yes, because a lot of people, are concerned about her, and I guess what she can't control. But there might be different medical reasons that we don't, aren't privy to, of why a conservatorship is in place. So yeah. It's just but very buzzworthy.
Yeah, well, she did seem to have some break. I mean, in the press, I think when she cut off all her hair and went bald. And I think my recollection from just the recent articles was I think that her father still maintains some sort of interest in the conservatorship. So
He does.
it does sound like the court's at least concerned that she may still need some help. Even as popular and successful as she is, there may be something there that we don't know that the court does know about decision making. But at least as long as it's as public as it is, it's going to be very hard for anybody to take advantage of her, I would think.
Yeah, like you were saying, now with that, you still have to report like monies to the courts and things of that nature. It's not a spree per se. You still have to be held accountable for the money. Is that correct?
That's right. And I think I think Britney Spears' biggest issue is she wanted to sort of be in control of her funds again. At least, in Maryland and DC, what the process is that when you initially become a guardian of the property or a conservator, you have to take stock of everything, whether it's houses or valuable furniture or bank accounts, and get it in your name. And then you file a inventory with the court so that the court knows sort of initially what you've got. And then once a year, you have to file an accounting where you list all of the money or income that came in, or all of the property received if you got gifts, and all the expenses. And typically, since everything should be going into a guardianship account, it's usually pretty easy to show that you are using the money for somebody's benefit, because you can have a record whether or not you're writing checks, or the bank has a good sort of electronic notations with your online banking. But the, for instance, trust office in Prince George's County, they have auditors. So you send in your accounting to them, they'll look it over, they'll make sure, they'll look at the bank statements. If they want receipts, they'll do that. If there's any questions about what's going on, they'll call you, and they can do an audit, that sort of thing. But the court will actually look at it, get a report from the auditor, and then a judge will look at both what the conservator filed, what the auditor did, and make a decision. Are we approving what was done, or do we need something additional? So there's a lot of safeguards for people who's got guardians of the property.
Mhm. Now, we talked about some instances of people, especially able people, or someone with dementia. Are there any other things that you've seen people come to you seeking guardianship for, or anything we haven't mentioned?
I would say, someone who's been in an accident, or needs medical treatment. A lot of times the family can make those decisions even for an adult. Some states, like Maryland, has the Healthcare Decisions Act, which will give doctors, nurses, the ability to rely on a family member to make certain decisions, but it's kind of the discretion of the medical provider. And so it's simply a little bit stronger, more sure to go ahead and get a guardianship, because if you have a medical issue that's likely to get worse, then it may not be mental, but if it ends up putting you in a state where you can't respond, then you might as well make sure that all of your medical providers know who will be making decisions for you, because you don't want to be in a situation where there's an emergency. I can remember one case I had where we had to do something on an emergency basis, and a woman almost died because the doctor had to give her a antibiotic, which turns out she was allergic to. And so she was really in sepsis, which is, the body poisoning itself, and then had an allergic reaction and very nearly died. And at that point, her medical providers weren't willing to make a decision as to what medication to give her. And we had to get into court within 24 hours and try to do something on an emergency basis. But you never know, how quickly it will take to get a guardianship judge or an emergency. And that's sort of in the best times, not even in the COVID times. But if you have any inkling that you have just a physical medical issue, as opposed to just a mental one where you could decline, where you may need someone to make a decision, you'd have to consider guardianship. And those can be temporary. And I know I've had cases where someone has gone into court and consented to a guardianship, even though they were mentally very with it, and the court noted that in the guardianship orders. And for that person's protection, the court noted that they were mentally competent, why they were doing the guardianship, and made it very specific that the alleged disabled could motion themselves to end the guardianship. So I think that's kind of a third, possibility, when you simply know things are not going to be getting better and may get worse, and you want to make sure that somebody will be able to make decisions for you.
Yeah, so that's done more out of a precautionary manner. Like, I might have something that advances, and I might get to the point of not being competent anymore, but I have this in place. Is that correct? Yeah.
Right. And that's why a lot of times the courts require that the doctor, when they do the certificates of incompetency, do it within 21 days, because you may be going in for a medical procedure and you may know that, for instance, they're going to put you in an induced coma for a little while because they want you to be able to heal. But 21 days later, you may very well be brought out of the coma and, able to make decisions again. So the courts are very careful to make sure that these sorts of things are done in real time, at least, within 21 days when the doctor's examined you.
Okay. Now, are there any specifications to being a guardian, or who can be a guardian?
Almost anybody can be a guardian who's interested. There's a statute that has a list of people who would have priority to be guardian. Like if more than one person wants to be a guardian, if someone has been named a power of attorney, they're at the top of the list. If there's no power of attorney, then a spouse would be at the next rung. And at that point, I think lower down you would have, brothers and sisters. Lower down you would have parents. But it can go all the way to anybody with what they call a beneficial interest in someone. I've actually seen in courts where banks have become guardians of someone's property because someone has become incompetent, not paid their bills, and they don't have family, but someone has to keep, the house from going into foreclosure. So literally anyone can become a guardian. To my mind, it's always better if family does it. They're going to know you the best, and they're probably going to make the best decisions with, your interests more at heart. Maybe not, every time, but anybody can do it. And there's just simply a priority list of who would be entitled if more than one person wants to serve in that role.
Okay. So that's a good question. You mentioned power of attorney. So power of attorney versus guardianship. We had an earlier episode where we talked about power of attorney when we was talking about estate planning. So what really is the best, or what's the best to use when, if you could break that down between power of attorney and guardianship?
Sure. Well, I would say the least expensive option is probably the powers of attorney. And if you get someone very early on in the process, or even now, if there's somebody that you trust, you're not sick, but you don't know if you could be in a car accident or something tomorrow. It's always good to have a power of attorney in place, so someone will be able to act for you. We do two kinds of powers of attorney. One is a power of attorney that starts work the moment you sign it, and the other one, if you don't want to kind of hand that power authority over to someone, is what they call a springing power of attorney, which means that you sign it now and there's no authority until an event happens. And when that event happens, the power springs into being. And you can put any event as the springing or the trigger event. Like typically someone will say that the power of attorney will become effective, for instance, when my own doctor, my primary care doctor, signs a certificate of incompetence saying, I need help, or certifies that I need help in some way. But you can, do either kind of a spring power of attorney or a power of attorney that happens immediately. They're certainly easier and less expensive to do. The state of Maryland actually has powers of attorney that are standard, and most people are supposed to accept. At Byrd, we do more complicated powers of attorney. For instance, when you're doing certain elder law and estate planning, especially, for instance, things like Medicaid or other disability actions for government benefits, sometimes those authorities aren't in the standard powers of attorney, and so it can be kind of costly not to have something that's a little bit more inclusive. But if you can do a power of attorney, that's one way of avoiding your guardianship later, because you have something in place that will allow somebody to act for you. It's kind of a tough call whether or not a power of attorney will make more sense than a guardianship, because power of attorneys can be revoked at any time. The way the law works in both Maryland and DC, a person is competent, or presumed competent by the world, until a judge says they are not. So you could have somebody who is incompetent, they have got some sort of progressive dementia, it's gotten worse, and maybe they have become defensive or aggressive because they're dealing with a disease. They may not necessarily know how to disease, or it makes them anxious. And I have seen it where someone has revoked the power of attorney, or in the case of families where there's a dispute, and this can happen, that especially in larger families, different people may feel like there is a better or different way to help mom and dad. And so what ends up happening is that one person who may have been power of attorney for 10, 15 years and has been doing, all the work, mom or dad is suddenly angry at them, revokes the power of attorney, and another person in the family becomes power of attorney and starts taking over everything and maybe making decisions that are undoing what the first person did. And chances are the first person was doing the best job because they were doing it at a time when the alleged disabled was still, fully competent, knew what they were doing, and it's easier to know how to act the way someone would have wanted you to act when you know that they were 100%. And so powers of attorney they can be revoked. And so although they're easier and less expensive, what happens if they do get revoked and you get what I call dueling powers of attorney? You have one child saying, well, this power of attorney is good, and another one is saying this one is good. And in fact, even after one is revoked, the new one can be revoked. And so I've seen it go back and forth. Guardianships are better when there's any kind of possibility like that, because guardianships keep going on until they are terminated by the court. And so you can't simply say, I'm power of attorney. When there's a guardianship in place, if, for instance, a bank is presented with a power of attorney and guardianship orders, they ignore the power of attorney because powers of attorney stop when a guardianship order is created. And you can't simply turn around and say, well, the guardianship is over. You have to actually show somebody an order from the court, the judge who's been monitoring, the alleged disabled person's case, that says, okay, whatever the disability was, it's over. And so this person is now competent again to make decisions. When someone, for instance, we were talking about a senior having Alzheimer's or vascular dementia, that's not going to get better, especially with the Alzheimer's. It's always, a slow decline. And so once somebody is adjudicated to be incompetent, they're going to remain incompetent, I think, for the rest of their life. And whoever is appointed guardian is going to be making those decisions, and you won't have to worry about the dueling power of attorney problem.
Okay. Thank you. So that's good to know on both sides, I guess, the pros and the cons of that. What if a situation, we'll give a little scenario here. What if I live in Maryland now and have guardianship of my adult sibling who also lives in Maryland, but one of us moves to another state? Does anything change about the guardianship from state to state?
Could be a little, could be a lot. And it probably depends on whether or not the guardian is moving, or the alleged disabled at that point would be the ward, the person who's sort of a ward of the state or the guardianship. If you, as the guardian, move from Maryland to, say, the District of Columbia, it's okay. I mean, you are still close enough. You can do whatever you need. Decisions can be made. We've had people live all the way across the country and still act as guardian because email, phone, FaceTime, all sorts of ways just to make sure that people can stay in contact. Because again, as long as people have the ability to act and become informed, they're going to be able to do that. I think many people think that someone who lives in the area is going to be a better guardian, simply because, osmosis, you're there, you're soaking up everything that's going on, but it doesn't necessarily have to be that way. The only kind of legal difference I know for the guardian having moved out of state is that you have to appoint a resident agent for services of subpoenas or lawsuits within the state of Maryland. because that's where the case is. So if you move to Virginia, you will have to file a resident agent form with the Maryland court, for instance, that says I have designated this Maryland resident to be my resident agent for service. It's a little bit more complicated, I think, when the disabled person moves out of state. It doesn't change that the person is disabled or that they're under guardianship, but whether it's a power of attorney or an order, they're only as good as the people that will accept that piece of paper. Many times, what you'll end up doing is you'll end up enrolling a guardianship order in the foreign state. That way, you can actually have local services kind of have some sort of confidence that, yes, this is the guardian. I don't have to worry about whether this is a Maryland order or a District of Columbia or a Virginia order. I know that it's my state's order. And I've seen people change and actually move the case from, saying, Maryland to another state because it's easier to get government services for the disabled. When, for instance, someone in Florida wants to make sure that if they're going to be providing certain adult protective services or certain food-related services, but they want it to be administered by their court. And in that case, you may ask the Maryland court to go ahead and transfer it to the new state. And so I think that's just really dependent on the state and what services somebody needs. Because technically, if you have a guardianship order, you remain the guardian. Doesn't matter whether they're here, they've moved, you're here, you've moved. But again, you want to just make sure that whoever's help you need accepts the piece of paper that you have and that you're getting the best services for someone that you can.
Wow, thanks. That's a lot of information, and we've barely scratched the surface, I guess, of guardianship. Was there anything else you want to add about tips for the process or anything potential guardians would need?
Sure. You'd asked about whether or not anybody can be a guardian, and I think the basic answer is just about anybody. One thing is that the courts will provide training. I know, for instance, Prince George's County has a lot of Zoom links for people who are going to, act as a fiduciary or have to do an accounting, that sort of thing. In fact, I know Maryland courts make it mandatory that you go under this training. You don't have to be a CPA to be a guardian of the property. You just have to be somebody who's taken the training, understanding that the courts have a lot of resources if you need help with the accounting. Just because there's an auditing department, I think the word auditor can be pretty scary, but the auditing department is actually there to kind of help you to make sure that you've got everything done right. They can get you whatever materials that you need. So I think anybody can be a guardian, and I think they don't need to be afraid of not knowing how to do it, because the courts deal with people all the time who are just trying to help family, and it's probably, like I said, best if you've got family members in there helping, and they will make sure that you've got the information that you need, and that the people in the trust office will help you with the things that you don't understand.
Thank you for that. Thank you. And thank you for your time. On behalf of PGCMLS, we would like to thank Byrd and Byrd, Attorneys at Law, LLC. Also, you, Tim Leahy, for taking time to talk with us. Thank you so much. And we also invite everyone viewing this to check out our free online resources such as Gale Legal Forms, which offers Maryland, District of Columbia, Virginia, and federal legal forms for wills, name changes, contracts, and more. So definitely go on and check out those free resources. We thank everyone for tuning in, and we will see you next time.